Estates in land define the type of interest held and any restrictions on it, only as long as the property is a bank. Two characteristics of estates in land: possessory now or in the future. I may possess it later. Measured by duration. I have this for life, then it goes to little o. Season is what distinguishes freehold estates from non-freehold estates. Season equals freehold. No season equals non-freehold. Freehold estate. Fee simple, absolute or defeasible. Fee tail. And life estate. Non-freehold estate. Estate for years. Periodic estate. Estate at will. And estate at sufferance. Fee simple absolute, or FSA. Fee simple absolute is the least restricted. Fewest restrictions, infinite duration, and descendable even to collateral relatives. Words to create a fee simple absolute. To O and his heirs. Note, the majority view does not require "and his heirs" to convey a fee simple absolute. Types of fee simple defeasibles. Fee simple determinable. Fee simple subject to a condition subsequent. And fee simple subject to an executory limitation. Fee simple determinable example. If grantor conveys to O and his heirs so long as the premises is used as a bank. O receives a fee simple determinable, while G retains a possibility of reverter. Words to create a fee simple determinable. While, until, for so long as, during the time that. Remember, a mere statement of grantor's purpose usually does not convey a fee simple determinable. So O can build a bank. Possibility of reverter and the rule against perpetuities. When a grantor retains a possibility of reverter, the rule against perpetuities does not need to be satisfied under the common law view. Important. Many states invalidate the possibility of reverter after a certain time, for example, 40 years. Fee simple subject to condition subsequent. If grantor conveys to O and his heirs, provided that O runs a bank, grantor retains a right of entry, and O receives a fee simple subject to condition subsequent. My estate only ends if grantor re-enters. Words to create a fee simple subject to a condition subsequent. Upon condition that, provided that. No right of entry? Many courts will treat this as a covenant instead of a fee simple subject to a condition subsequent. Right of entry and the rule against perpetuities. A right of entry is not subject to the rule against perpetuities under the common law. Important: many states invalidate a right of entry after a certain time, for example, 40 years. Fee simple subject to an executory limitation. If G conveys to O and his heirs, but if O does not have children, to A. Grantor has given O a fee simple subject to an executory limitation, and G has given A an executory interest. An executory interest must comply with the rule against perpetuities. Fee tail. To O and the heirs of his body. Only passes to blood relatives. Note: the fee tail has been rejected or modified in U.S. law. Some states modify the fee tail in one of the following ways: a fee simple conditional, fee tail with disentailing conveyance, a life estate with a remainder, or a fee tail with a fee simple absolute in the grantee's issue. Life estate. To O for life. O has a life estate until death and is known as a life tenant. Life estate per autre vie. To O for A's life. O has a life estate until A's death, and A is known as the measuring life. Words to create a life estate. For life. During his or her life. Until death. A life tenant cannot sell or mortgage unless the conveyance expressly allows it. Life estates can be defeasible. To O for life, so long as he pays property taxes. A life tenant may lease the premises and keep all rent. The lease ends when the life tenant or measuring life ends. The life tenant can convey up to a life estate. Here's a fee simple determinable. Here, have my life estate. Duties of a life tenant for operating expenses. Reasonable repairs and property taxes. These are paid only to the extent of benefits. In other words, rents collected for fair rental value. A life tenant has a duty to pay a mortgage only to the extent of benefits. In other words, rents collected for fair rental value. I only have to pay as much as this property makes. A life tenant has a duty not to commit waste. The life tenant and ameliorative waste. The traditional view prohibits this, but the modern view says it's okay if the value of the future interest does not decrease, and a rational person would still want the property as changed. Types of future estates. Possibility of reverter, right of entry, reversion, remainder, and executory interest. When a grantor conveys a fee simple determinable, he retains a possibility of reverter. This is descendable, divisible, and in some states may be conveyed inter vivos. When a grantor conveys a fee simple subject to conditions subsequent, he retains a right of entry. In most states, this is divisible, descendable, and transferable inter vivos, unless incident to reversion. A right of entry incident to reversion results when a grantor retains a right of entry and a reversion. This is generally not transferable inter vivos. A reversion is retained when a grantor transfers a lesser estate, in other words, less property rights, to another. Divestment happens when to O for life, then to A and his heirs if A survives O. Circumstances make it clear that the grantor's reversion cannot become possessory. Here, A survived O, so grantor's reversion cannot become possessory. A remainder exists when the non-possessory estate can only be possessory on the natural termination of the one granted to O. Vested versus contingent remainders, Part 2. Vested remainders are not subject to the rule against perpetuities. They are transferable inter vivos. Contingent remainders are subject to the rule against perpetuities. They are not transferable inter vivos. And they are subject to destruction. Note that these are the common law distinctions. Some states have changed these rules. A contingent remainder may become vested once a condition precedent actually occurs. The children who survive B have a vested interest upon B's death. Contingent remainder with unascertained remainder person example. Here G gives O a life estate and a remainder to B's children. I have no kids. Until B has children, this remainder is contingent. A contingent remainder can be destroyed unless it vests at or before the termination of the preceding estate. This can occur by natural termination of the preceding estate or merger of preceding freehold estates. Caution: this applies at common law and about 25% of states today. Destruction due to preceding estate's natural termination. Grantor conveys to O for life, remainder to O's oldest son B when B turns 25 years old. If O dies when B is 22 years old, the remainder is destroyed. Alienability of remainders. Vested remainders are transferable inter vivos, divisible, and descendable. Contingent remainders under the majority rule are transferable inter vivos, divisible, and descendable. Note, the minority rule, which is common law, a contingent remainder is not alienable. If a grantor grants O a life estate and the remainder to O's children, the rule in Shelley's case will change this conveyance to a fee simple absolute in O. Caution, this is a very small minority rule. The rule in Shelley's case applies if the interests are either both legal or both equitable. If G conveys an estate to O for life, then to G's own heirs, the doctrine of worthier title will invalidate a remainder given to one's own heirs by conveyance or will. Livery of season was a ceremony to transfer freehold estates. I must take possession now. Common law restrictions prior to the statute of uses. A freehold estate cannot be created in futuro or in the future. A grantor cannot convey an estate that cuts short another or a shifting interest. No gap between expiration of one estate and the next. Courts of equity, also known as courts of chancery, granted relief where a use existed and when strict application of the common law bore a harsh result. Oh, sorry, I cannot give you legal title. Defendant, you must use the land to O's benefit. Before the statute of uses, to X and his heirs, to the use of O and his heirs, would result in X having legal title and O having equitable title. But the statute of uses would execute O's equitable estate into a legal one. Here, X has no title. Executory interest versus interest retained by grantor. Executory interests are always in a person other than the grantor. Executory interests versus remainders. No longer a bank, I have a right of entry. X's right of entry is an executory interest that cuts off O's prior estate. In almost all jurisdictions, executory interests are divisible, descendable, and transferable inter vivos. Waste is a concern to holders of future interest. Hey, I'm gonna have that when you die, since the actions of the present possessor could impair the future interest. There are three types of waste in dealing with future interests: voluntary waste, permissive waste, and equitable waste. There are several remedies available for waste to a future interest holder: damages, injunction, and a judicially ordered sale. The rule against perpetuities is designed to protect against dead hand control by the grantor.
You get nothing. You take it all.
Under the common law rule against perpetuities, the validity of interests is judged at the creation of the interest, not when it may vest. There, just finished. Let me check that over. The rule against perpetuities invalidates only those interests that violate the rule. However, this may change the nature of other valid interests in the conveyance. Take out this and this. What the rule against perpetuities does and does not apply to: Part 1. The rule does apply to executory interests and contingent remainders. The rule does not apply to vested remainders and reversionary interests. What the rule against perpetuities does and does not apply to: Part 2. The rule does apply to options to purchase land in gross and rights of first refusal. The rule does not apply to land use restrictions, for example, equitable servitudes, and options to purchase exercisable only during the lease period. Identifying the lives and being under the rule against perpetuities is usually done by finding the parties named or referred to in the instrument. To O for life, then to O's first child to reach 21 years of age. There are times where the measuring life is not mentioned, but it will be causally related to the vesting or termination of the interest. To O for life, then to O's first child to reach 21 years of age. Here the measuring life could be the last of O's children to die. A child is considered in being from conception if that child is later born alive. The fertile octogenarian rule of the rule against perpetuities presumes that any person, regardless of age or physical condition, is capable of reproduction. I'm due on June 12th. The unborn widow problem of the rule against perpetuities will generally invalidate an interest to a person described as a widow in the instrument, as opposed to a person actually named in the instrument. Not all widow conveyances will be invalidated by the rule against perpetuities. It must be a widow of someone other than the testator. Many courts allow evidence to show the widow was a specific person, and wait-and-see jurisdictions will know who the widow is. The rule against perpetuities will invalidate an entire class gift if even one member's interest violates the rule. Rule against perpetuities example with the class gift and the fertile octogenarian rule, Part 1. This shows how the rule voids interests based on what might happen.
I'm 87 with 3 kids.
Assume the conveyance is from T to O for life, then O's surviving children for life, then to the surviving children of X.
Just had this one at age 90.
The interest to X is void because of what could happen. Many jurisdictions adopt a wait-and-see approach, where the actual result matters rather than a possible one. Assume the conveyance is to X and his heirs, but if X or his heirs use property as a casino, then to O and his heirs. Under wait and see, O's gift is valid if there's a casino within 21 years of a life and being. Under the Uniform Statutory Rule against perpetuities, the perpetuities period is increased from the common law 21 years after a life and being to 90 years.
Is this all valid?
We'll see in 90 years. Restraints on alienation of property. But you can't transfer to anyone else. Are generally disfavored by courts. States govern marital property rights in one of 2 ways. The common law system in a majority of jurisdictions, or the community property system. This is in a minority of jurisdictions. A tenancy by the entirety shares characteristics of a joint tenancy, except it is only between husband and wife, and it cannot be severed during the marriage. A tenancy by the entirety is recognized in 22 states. Married Women's Property Acts help protect women's property against claims by creditors of the husband.
He owes me.
I'm sorry, but I own this house. Property division at divorce under the traditional view goes strictly by legal title. Equitable distribution is the modern means of property division for a divorce.
I worked hard.
So did I. We'll split the property fairly. Factors generally considered in equitable distribution. Duration of marriage. Parties' roles in acquiring or raising the value of property. Age, health, occupation, income, and employability of each. And the contribution, if any, as a homemaker. Equitable distribution only applies to marital property, which is generally limited to property acquired during the marriage from the parties' earnings. Bought with earnings during marriage. Gift to wife during marriage. Husband bought this before marriage. Dower rights in a widow at common law were not disrupted by husband's conveyance to a third party. My husband just died. You owe me 1/3 of what he gave you.
Huh?
Widowers received property by courtesy, and received all inheritable land provided a child was born alive to the couple. The red portion is a life estate owned by the wife. This is not inheritable, and thus not included in courtesy. The widower will receive all of the green portion, which is the wife's inheritable land, given, of course, that this husband and wife had a child that was born alive. Only 5 states now recognize some form of dower or courtesy, and they require both spouses to sign any deed for the transferee to take title free and clear. Elective share statutes operate to prevent spouses from depriving one another of an inheritance from probate assets. Your husband left you a stapler in his will. I will take against the will then. The estate used to calculate the elective share can include things such as gifts close to death designed to prevent a spouse from getting property through the elective share.
Give those 3 houses to Joe.
Go ahead. They'll still be counted in your estate. Some elective share statutes will evaluate the length of the marriage to determine the share available to the surviving spouse. 5 years. 10%. 50 years. 45%. The community property system views marital property as the joint efforts of husband and wife, regardless of earnings.
Go team!
The 3 major categories of separate property are property acquired before marriage, property acquired by gift, inheritance, or bequest, and income earned from separate property, for example, dividends, interest, or rent. Note, in 3 states, Texas, Idaho, and Louisiana, income earned from separate property is treated as community property. Other categories of community property include income from community property, proceeds from the sale of community property, and income produced by labor of either spouse, for example, wages, commissions, pension benefits, etc. To the extent separate property is used to acquire property, I'll pay for half with money my uncle left me. Courts will commonly treat it as part separate property and part community property. The status of real property is determined by the law of the state where the property is located. We live here but have a summer home in California. If the real property is in California, then California law applies. The status of personal property is determined by the law of the state where the couple is domiciled at the time of acquisition. A table acquired while the couple lived in Florida is Florida property, even if they moved to Texas. For the California exception involving quasi-community property, see the next video. California quasi-community property treats community personal property acquired as something between community and common law property. The non-owner spouse gets a 1/2 interest at death or divorce, while the owner spouse has full rights to control, dispose of, and devise the community personal property. Separate property may be changed to community property by the owner's spouse agreeing to treat it as such. Let's make this community property.
Okay.
Divorce under the community property system gives courts discretion to divide community property, while separate property goes to its respective owner.
I'm splitting your community property. Keep your own separate property.
Death of a spouse under the community property system permits the deceased spouse to devise his share. If there's no will, the result varies by state. Husband left his half to Aunt Millie. Common law marriage occurs when a couple lives together and holds themselves out to the public as husband and wife.
We're married.
Cohabitation does not result in the same marital property rights as common law marriage, although some courts will enforce contracts to share expenses or split earnings.
We live together.
We're married. Same-sex marriages allow same-sex couples to marry and enjoy the same rights and duties as other married couples. 6 states currently perform and allow same-sex marriages, while another 2 jurisdictions, New York and the District of Columbia, recognize those performed in other states. Civil unions and domestic partnerships afford same-sex couples similar but not the exact rights and duties that officially married couples enjoy in their respective jurisdiction. Note, the rights and duties granted in civil unions and domestic partnerships vary from state to state. Homestead exemptions are designed to protect the family residence up to a certain dollar amount or acreage, which varies by state. They owe me a lot of money.
Sir, this is a protected homestead. Go away.
Other homestead law information. Exemptions do not apply to purchase money mortgages. And if the title to homestead is held by one spouse, the surviving spouse will likely have some protection against creditors of the deceased spouse's estate. There are 3 main ways to co-own property: joint tenancy, tenancy in common, and tenancy by the entirety. A joint tenancy occurs when 2 or more people own a single interest with the same rights, including survivorship.
We can all enjoy this entire house.
Joint tenancy and the 4 unities. The unity of interest. All joint tenants must have the same share and duration of property interest. Here, these joint tenants each have a 1/3 interest. And they each have it for life. Unity of title and time. All joint tenants must acquire title by the same instrument. You're all mentioned in here, and our interests vest at the same time. And those interests must vest at the same time as other joint tenants. And you can all enjoy the whole place. Unity of possession. All joint tenants must have rights to possess and enjoy the entire property. Presumption of ambiguous co-tenancies. At common law, it was as a joint tenancy. But under modern law, the presumption of an ambiguous co-tenancy is as a tenancy in common. There are several methods of creating a joint tenancy, including express conveyance. In some states, even an owner in fee simple can convey a joint tenancy to one person and himself. The right of survivorship is essential to a joint tenancy. We now own 1/2 undivided interests. When one joint tenant dies, the remaining joint tenants succeed to the entire interest. Creditors of one joint tenant generally have no rights against the other joint tenants of the property. He died owing me money. We succeeded to his interest. Sorry. Severance of a joint tenancy typically creates a tenancy in common. I'll sell you my interest. Here's a severance of a joint tenancy by sale. Now red and purple are tenants in common. They have no rights of survivorship. Conveyance of an interest in a joint tenancy of 3 or more people. I'll sell you my interest. Results in a joint tenancy between the remaining joint tenants and a tenancy in common with the new party entering the co-tenancy. In a title theory state, which is a minority, a mortgage is viewed as a conveyance and I'll mortgage my interest severs the joint tenancy, allowing the mortgagee to foreclose. In a lien theory state, which is the majority of jurisdictions, a mortgage is viewed as a secured lien. I'll mortgage my interest. And does not sever the joint tenancy. Note, courts are split on whether the mortgage is enforceable if the mortgagor tenant dies first. Most courts hold that a joint tenant leasing to a third party, can I rent from you? Sure. Does not sever the joint tenancy, since the lease only applies to the lessor's interest. Partitioning a joint tenancy severs it and can be done by physical division or splitting the proceeds of a sale. Here's the money from the sale. If one joint tenant contracts to sell their interest, when is severance? Before the sale. Once the sale is done, courts are split. Joint tenancy and the right of survivorship have been abolished or modified in a few states. Georgia and Oregon have abolished joint tenancies, while this group of states has chosen to modify. A tenancy in common is a form of co-ownership where people hold separate, undivided interests in property with no right of survivorship. Tenants in common may hold shares unequal to one another. Ha-ha! Since there is no right of survivorship with a tenancy in common, these interests are descendable and divisible. He left me his interest. I'm a tenant in common now. Tenancies in common may be created by operation of law. For example, if a will says children take property equally. O left this house to you equally. This creates a tenancy in common. A tenant in common may convey his interest without consent of other tenants.
I'll sell. Hey.
Mortgages or judgment liens against one tenant in common are only effective against that tenant's undivided interest. You didn't pay. I'm getting a lien.
It'll only be against me.
Easements and boundary disputes settled by one tenant in common does nothing to bind the other tenants in common. Let's settle this boundary dispute.
Okay, sure. I am not bound.
A tenancy by the entirety shares characteristics of a joint tenancy, except it is only between husband and wife, and it cannot be severed during the marriage. A tenancy by the entirety cannot be severed. Give me half. Nope. But let's change to a tenancy in common. Spouses can mutually replace it with a joint tenancy or tenancy in common. What if a spouse has a creditor and property interest in a tenancy by the entirety? Creditor wins, but can't attach. Creditor wins and can attach the interest. Courts are split. Some courts allow attachment, while others, the majority of jurisdictions, do not. Divorce terminates a tenancy by the entirety, resulting in a tenancy in common under the majority view, or a joint tenancy with survivorship rights under the minority view. Simultaneous death of spouses will result in treatment of the property as if it were held as tenants in common. Assuming the jurisdiction recognizes that spouses have equal rights of control, the rights and duties are the same for all co-ownership forms: tenancy by the entirety, joint tenancies, and tenancies in common. Only one co-tenant possessing with no ouster.
I'm not there, so co-tenant 1 should pay rent.
Ha! I'm not paying co-tenant 2 rent. Has no duty to pay fair rental value or share profits from the property. Only one co-tenant possession with ouster.
If you don't let me in, you owe me rent.
Must pay fair rental value to the others if ouster is physical prevention of entry. If the occupying tenant depletes or lowers the value of property, for example, if co-tenant 1 starts a lumberyard, this gives rise to a duty to account to the out-of-possession tenant, who here is co-tenant number 2. If a co-tenant leases to another, he must share rent with his co-tenants. Here's my rent. Share with us. A co-tenant paying property taxes or making mortgage payments, may deduct payments from rents received or be reimbursed from proceeds of a partition sale.
I'll get repaid by my co-tenants.
One co-tenant paying for repairs other co-tenants know about can deduct it from rents or get reimbursed from sale proceeds in most jurisdictions.
The other guys ain't chipping in?
I'll get paid back from rent or sale proceeds. An equitable action for partition results in either a partition in kind or by sale.
Divide or sell.
Partition in kind is dividing property between co-tenants. And usually happens when the property is easy to divide and the parties agree. Partition by sale is dividing sale proceeds between co-tenants, and usually happens when it would be impossible or unfair to divide the property. Property rights include the right to possession, right to use, right to transfer, and right to exclude others. Note, an owner of property may have any combination of these various rights. Right to possession. I have the right to possess this building. Right to use. I have the right to use this building as a bank. Right to exclude others. Get off my property. Right to transfer. Sale. I can sell it. Gift. I can give it away. Or other. He left it in his will. Remember, an owner has property rights determined by local, state, and federal law. Possession versus title. I control this land. Possession is dominion and control. I legally own land. Title is the legal right to own. Courts of law award damages in the form of money only. O wins the case. O is awarded money. Courts of equity order injunctions and other forms of relief. D. You must stop being a nuisance to O's property. Why equity versus law is still important. The type of relief available, in other words, equitable or legal, depends on the cause of action filed. Ambiguous land grant? Courts favor a complete transfer over a partial one. A rule of law is a mandatory result under applicable circumstances. For example, the rule in Shelley's case. I must rule for X. But I clearly intended something else. A rule of construction is used to interpret an ambiguous property grant. The grant was ambiguous. I'll use a rule of construction to resolve this.